But ultimately, policy takes time. Getting legislatures to move on socially controversial things can be difficult, although I would argue this should not at all be socially controversial, that you shouldn't be able to mutilate confused and traumatized children through surgical procedures. But that aside, often those kinds of policies take a lot of time and political capital and effort to get through. But jury verdicts tend to end things like this. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week, we'll be covering the first major jury verdict in a detransitioner lawsuit. That's a big news item that we wanted to make sure we cover. Then we're going to talk about a Fourth Circuit case upholding a compelled speech law. And then we'll finish up with a lawsuit from a father in Texas concerning abortion drugs that were mailed into the state of Texas from California, which highlights an ongoing battle between states that protect the unborn and those that aggressively push abortion. So lots to cover. Let's jump into this first issue, which most of our listeners have already probably heard something about, but we figured it's an important case. It could be a watershed moment on the transgender surgery issue. And so we wanted to make sure we give it a little attention here. So if you have not already heard, I do want to cover some of the facts in detail because they are quite relevant to how we got the verdict. So, this is a civil court jury trial in Westchester County, New York, that recently awarded $2 million in damages to someone named Varian Fox after she sued her former psychologist as well as her surgeon. So, again, this is a minor. She was 15 years old at the time. She began seeing a psychologist named Kenneth Einhorn for counseling sessions while she struggled with some gender dysphoria issues. There was apparently a lot going on, some serious underlying trauma, which wasn't really paid too much attention to. And I will caveat here that this is not public trial record, if I'm remembering this correctly. So most of this is through secondhand reporting sources. I assume more will be confirmed, but this does seem to be a pretty established narrative. So the therapist quickly encouraged Fox to begin wearing chest binders, to change her name to a male name. Within about a year or so of this, at the therapist's guidance, Fox underwent a double mastectomy at the hands of a plastic surgeon named Simon Chin. So again, this is something that we're going to see a lot more of. This is a very common pattern, but Einhorn, the therapist, told the child's mother that the only way to prevent suicide was to go permanently scar her body with a double mastectomy. So Fox, it seems, almost immediately regretted the procedure. This was a pretty fast system of regret and trauma from this. Fox's mental state declined further. She began to engage in self-harm. The magic mental health improvement promised by these surgeries did not happen. And so we end up in a lawsuit. The court here found both the therapist and the plastic surgeon liable for damages, distributed the penalty between them 70-30. There was about $400,000 for future medical expenses included in the jury verdict, with the understanding that the damage is not done when you do things like this to minors. During the trial, the child reflected that when she was only 16 years old, clinically anxious and depressed, she says, "I was not mature enough to make the decision to have surgery, and I certainly wasn't mature enough to handle the aftermath." So, unfortunately, very common and quite tragic situation. And the legal claims, again, the opinion from the court, the details are all being obtained secondhand at this point. But the basic gist of the claim is that both the therapist and the surgeon failed to follow basic medical guidelines, even those that are promulgated by organizations like WPATH that have led the way to supporting these mutilative operations on minors. For example, the therapist met with Fox only twice for a total of 60 minutes in the weeks leading up to the mastectomy. The referral from the therapist to the surgeon omitted other aspects of Fox's diagnosis besides her gender dysphoria. As we said, it seems pretty clear there was a lot of trauma, anxiety, other things going on besides gender dysphoria that probably should have gotten some attention before just performing a double mastectomy. The surgery was performed based on Einhorn's, the therapist's, incomplete information with little to no questioning. So, as noted by the the plaintiff's attorney, this lawsuit was about healthcare professionals who chose to empower, and that's in scare quotes, a patient instead of treating her. With this decision, it's like I said, a watershed moment. There are, I think, about 30 other similar lawsuits active in other courts that we've been able to track. There's a lot of news attention on this, and but this is the first public jury verdict of this kind. So, just I don't have too much commentary here. I think the legal outcome is fairly straightforward. Performing a double mastectomy on a physically healthy girl, right? She didn't have breast cancer or anything that would warrant this physically. This is a transgender ideology guided procedure. There's no other way around that. It clearly the way that it was done deviates from medical standards, ignoring the other trauma and emotional issue going on. Very little consultation before the surgery was actually performed. And then there's also just the question of consent, how a mentally ill minor can properly consent to permanent life altering damage through a double mastectomy is uh, horrifying and questionable at best. So, the two things that I just wanted to point out here is very quickly before I turn it over to Joseph are one, I think it's in particularly meaningful because this was not one of those targeted lawsuits, right? We see these over and over again, just to use an example, right? If a group hostile to the Trump administration is going to file, a lawsuit challenging an administrative action, they're going to shop for a judge in, a liberal court in, pick your place, New York, Hawaii, California, and so on. But I think this verdict is particularly impressive because this was not, hey, we want to attack, a gender transition, quote unquote, surgery. So we're going to go find like the deepest red state trial judge in Texas or Alabama or whatever. This is in Westchester County, New York, right? Hardly a bastion of social conservatism. If anybody's familiar, Westchester County is not the sticks of upstate New York. That's the county immediately outside of New York City. It's a blue county. It's not the place where you would expect someone to jury shop or judge shop to get a verdict like this. So I think that in itself speaks quite a bit to how things are moving on this issue. And the other thing that I'll say, and I'm not the first one who has commented on this since this became a newsworthy item, but I've been saying this for years. Again, I know I'm not the only one, that what will usher in the end of this experimental transgender surgery movement was always going to be jury verdicts, not policy. Obviously, policy is important. Like what we saw in Skirmetti, banning these kinds of surgeries on minors through, state or federal action is a good thing. But ultimately, um, policy takes time. Getting legislatures to move on socially controversial things can be difficult. Although I would argue this should not at all be socially controversial, that you shouldn't be able to mutilate confused and traumatized children through surgical procedures. But that aside, often those kinds of policies take a lot of time and political capital and effort to get through. But jury verdicts tend to end things like this, right? If this looks like kind of the maybe first wave thing, but uh, it's one thing if you have red states passing this, and then do people go move to blue states to do these kind of things in hospitals and surgical centers? Okay, that could take years before you end this practice, but I'm pretty confident that if you see jury verdicts, again, this is a seven-figure single incident settlement, but if you start seeing class actions against health networks, against major university hospitals where you're getting, eight, nine, 10-figure verdicts or settlements because, as it turns out, these doctors are not following protocols. They're doing very questionable things to children with um, sparse amounts of information. When the verdicts and the settlements start rolling out, people aren't going to be willing to pay the price, literally, to do this to children. So I think as we start to see more of these cases play out and either settle or go to jury verdict, and we start to see big payouts from these doctors and hospital networks for what they've been doing to children, I think we'll see this hopefully and likely come to an end. So, Joseph, again, not a very legal heavy question, but a very important one. So I'm curious if you have any additional thoughts on this.
Yeah, Frank, thank you for explaining what's going on here. And I love your second point that jury verdicts are really going to be the kind of driver of ending these experimental procedures. Like the policy can and will change, but the reality that doing these things to kids is horrific and violates basic ethical standards never will change. There's a piece by another woman named Claire Abernathy who also went through a mastectomy and started taking testosterone and these sorts of things. She recently published something kind of expressing her experience, and our comments echo similar ones made by Varian Fox in this case. Abernathy wrote stuff like, quote, minors cannot legally consent to many things. Why are we allowing them to chop off perfectly healthy body parts in the name of, quote, mental health? I will never be able to get back to what could have been. She said how she was a singer, but through testosterone and different kind of procedures, her vocal cords have been damaged. She can't reach the same tones and pitches like she used to be. She wrote, what's most painful to sit with is not just what has been taken from me, but how confidently it has been taken. This is not medicine. This is coercion disguised as care. Her experience is very similar to Varian's and echoing how, as a minor, you cannot consent to something like this. Regardless of the policies and recommendations that various institutions have in place, I don't think WPATH, a couple other medical associations in the last couple weeks, really after this verdict, have started saying we don't recommend these things for minors anymore, at least not all the time. But regardless of those policies and recommendations, performing and encouraging these procedures on kids will never be okay. Jury verdicts like this don't depend as much on policy. They depend on the true damage caused by doctors and psychologists that push kids into these permanently damaging operations.
And one thing I would just say to wrap this up is now I think it's starting to come out as a kind of 80-20 issue. I think that has happened over the last couple of years where a lot of light has been shed on this issue and a lot more, maybe not politically engaged or socially, culturally engaged people have come to see like what horrible things are going on here. But I think it's worth constantly, I've probably done this before on the podcast, but shouting out the voices who were putting a spotlight on this before it was popular because it was a very risky thing to do. Mary Margaret Olahan, who's now White House correspondent at the Daily Wire, but she wrote a book highlighting some of the stories of early detransitioners and what they had gone through. A lot of people are probably familiar with Chloe Cole, who was very early coming out as a detransitioner, talking about the harm that she went through. And I mean, even Matt Walsh's documentary at the Daily Wire, What is a Woman, several years ago, I think was a real like cultural watershed moment to highlight this at a massive level, what was going on and how spurious the evidence was, how much ideology was behind it. So again, it's easy to get on to an issue like this when the tide has already turned on it. But there were a lot of really brave people who came out there earlier and took a lot of flack for opening their mouths before this was a big popular 80-20 issue.
Yeah, absolutely. Like you said, very grateful to the people that kind of started showing this to be the cultural split that it is. Well, that will move into our second update where we'll talk about a recent decision from the Fourth Circuit that upheld compelled speech in public schools. So this has to do with the now infamous Montgomery County School Board of Maryland. For anyone familiar, that's the same school board from Mahmoud v. Taylor. But that school board currently requires public school teachers to use whatever pronouns and names a student requests. So if a boy says, I want to be called she and her, the school requires teachers to do so. So this woman, a substitute teacher named Kimberly Polk, requested a religious accommodation from those requirements. She said it's against her faith to call male students she and female students he. And her accommodation was pretty simple. She basically said, I'll call students by their last name and avoid using pronouns at all. That's a kind of common pattern we see in these sorts of things. However, the school board eventually denied her request, and she actually stopped teaching because of the issue. It was so severe that she said, I can't go in a classroom if I'm being forced to do this. So after about 2 years of being out of the classroom, she eventually sued the school board, basically asking for an injunction to make the policy not apply to her. So to be free to teach without being required to use these pronouns. And her lawsuit really centered on saying that the requirements violated her rights to free speech and free exercise under the First Amendment. And recently, a panel of judges at the Fourth Circuit upheld a ruling against her and upheld the school's requirements. So to repeat listeners of this podcast, this kind of fact pattern and legal analysis might sound a bit familiar. Last week, we talked about a case over free speech in public schools where basically a group of pro-life students, their group was shut down because they put a poster that said defund Planned Parenthood. There are some commonalities in those kind of cases and this one, but legally and kind of importantly, these are two very distinct things. Last week, we talked about the big question was, does Hazelwood apply when it's non-curricular speech? Here, the case comes down to two totally distinct things that we're going to take some time to unpack. The first is religious free exercise under Smith, which might be a bit familiar, but the way that this precedent works in this suit, there's some comments we want to add to that. So if you hear Smith and your eyes glaze over because you're familiar with it, like we promise we have something new to say here. And secondly, is if teachers, and this is really where the controversy comes in, is if public school teachers calling kids by the wrong pronouns is a matter of public concern. So on the first point, how does Smith work in this case? The way that Smith actually works is kind of familiar. Basically, the decision from 1990 set the precedent that when a neutral and generally applicable law burdens religious free exercise, it's only subject to rational review. Here, the Fourth Circuit held that the board's compelled speech requirement was neutral. It didn't facially target religious teachers. It didn't say this only applies to Catholics or Christians or whatever. And it was generally applicable because all the teachers are bound by it. As such, it only had to have a rational relation to a legitimate government interest, right? That's rational review standard. Um, and here the judges decided that in order to promote safety for students whose parents might not support their attempt to change sexes, to follow non-discrimination laws in Title IX, to hire staff that, quote, treat and nurture all students equally, the school board had a rational reason to implement the regulations and the requirements. Unfortunately, like I said, that's a pretty established pattern. The law doesn't target religion on its face, at least theoretically. It applies to everyone. Therefore, it doesn't matter if there's this burden on religious free exercise. But the one thing I really want to add to this point is that I think it's deeply wrong to claim that safety and nurturing students equally is actually advanced by the school's policy of requiring teachers to use preferred pronouns. The fact is, it is not good for kids to have teachers that pretend that boys can be girls and girls can be boys. And it is a tragic fact that courts typically assume that this is kind of a legitimate interest. But quite honestly, that's a tragedy. It is not safe. It does not promote equal treatment. It is not good for kids to tell a little boy that he is a she or a little girl that she's a he. Um, so with that, I do want to move on to the second point, but that's kind of I think my take on the rational review standard is that it is not legitimate for a government to say that boys can be girls. It's absurd. But the second kind of more legally controversial, at least in this case, is basically, is this teacher's speech protected under the Pickering test? As I mentioned at the start of the episode, the key kind of turning point here is whether or not the speech in question is a matter of public concern. So the Pickering-Connick test is, again, probably kind of familiar to a lot of our listeners. Essentially, it's been established through a couple of different Supreme Court cases, and it determines when a public employer can regulate an employee's speech. The very kind of short abbreviated version is that if the employee's speech is addressing a matter of public concern, that's kind of the threshold question to get into the second prong, then the court balances the employee's right to free speech with the government's interest in providing efficient services. Here, the court kind of from the gate said that we're not going to reach that second prong because they decided that the first prong was never met. They said that the teacher's speech, namely the manner in which she addresses and speaks to students within her classroom, is not a matter of public concern, largely because it's contained within her classroom. It doesn't kind of go outwards. But I think that's incorrect under the law as it's written. Under Pickering and Connick, the cases that developed this test, matters of public concern are defined by those that touch political, social, or other community interests. And I'll borrow from the dissent in this case from Judge Wilkinson. He wrote that there can be no question that quote-unquote transgender rights represent a highly contentious and significant issue in our social and political zeitgeists. If the issue is not one of public concern, I don't think of an issue that can be. So kind of the point that the matter of public concern is defined as socially and politically important. The way that we talk to kids that struggle with gender and identity is hugely important to our society and our community. So under the definitions that Pickering and Connick set for speech that is of public concern, I think it's clear that this is of public concern. And I'll close with this, even going slightly beyond the complicated and numerous letters of the law here. As a matter of legal and social principle, our country protects political dissenters from being forced to become the mouthpieces of the state. Here, the substitute teacher disagreed with the famously liberal school board about how to best interact with kids that struggle with sex and gender. And here the government is saying that either she must change her beliefs or lose her job. And that runs so counter to both our law and just our society at large and why America exists in the first place. So, Frank, that's some of what I'm seeing here. I'd love to hear what you have to add.
Yeah, just very briefly. I mean, the problems with the free exercise issue and the free speech issue essentially come down to the same thing for me is that we have government officials enacting policies that are extremely controversial, that are religiously and politically motivated, right? These are ideological decisions that a boy can be a girl and you have to call him a girl and vice versa. And so it makes, I think, both of the arguments kind of absurd. On the religious exercise side, this idea that this is a generally applicable neutral law is a farce. True, it doesn't say, Catholics must do X or Christians must be quiet about Y, but this is essentially not neutral or generally applicable. This is a religious belief that you can switch genders, whatever that means. And the same thing on the speech side is there's this fiction going on here that this isn't a matter of public concern, right? It's not a hot political, social, or other community interest. This is just the way that we talk about people and their choices, right? We're trying to make something harmless, settled, run of the mill, which is actually quite an ideologically contentious, fraught, religious, political, and cultural issue. So I don't need to go on that. I think we're wrong on both of these. I mean, I think Smith is problematic for many reasons, but this is one of them that the question of what generally applicable or neutral laws are is kind of elusive because it's not something as simple as you have to cross the street when the crosswalk turns green. Like, yeah, neutral, generally applicable. This doesn't have anything to do with your religious or political ideology. But there are a lot of in betweens, right, where there is something that's clearly much less neutral than the crosswalk law, but not as obviously religiously motivated as like banning Catholics or Christians from doing something on its face. So that's a problem. I don't think we've quite gotten there yet. It'll be curious. I'm curious to see. I know everybody's in the religious freedom movement is kind of chomping at the bit to find the case that will just overrule Smith entirely. There are some contenders pending on their way up right now. Um, that it's questionable whether that's the way that this will go or whether it'll just continue to be chipped away at, right? Maybe we narrow what counts as generally applicable and neutral. Maybe we continue to find exceptions to where we are going to keep using strict scrutiny in certain scenarios, or maybe we find the case that overrules it. I don't necessarily think that this is it. I think this is probably, while I might have reasons to disagree with it, they go beyond the scope of this conversation. But a lot of these cases where there are clearly both religious exercise and free speech issues, they become straight free speech cases. My guess is because this is literally a case of compelled speech that the focus on this one, if it continues to go up, is that it'll be argued on the free speech issue, which is not unimportant. But I do have to say, I understand strategically why litigators are choosing this, but I do think sometimes we're missing opportunities when we're taking things that clearly have religious implications and running them as straight free speech cases. Again, to be clear, I understand the strategy. It makes it so that the protections apply to more people, even those who are not explicitly religious in their reasons for speaking a certain way. Um, but I think that there are definitely downsides to choosing to make things straight speech cases when there are religious implications. But lest I repeat myself here, I think that was you covered this really well. And yeah, this is going to continue to be a problem when we treat things like calling somebody by pronouns or names other than the reality of their sex and treating it as if that's not a hot political or controversial religious secular kind of fight, as if it's just, as run of the mill as a law making people cross the street when the light turns green. That's a lie. With that, I think we will move on. Um, this one will probably be quick only because the legal argument right now is novel but fairly simple and it's early on in this case, but definitely needs some attention. We've covered this issue before, but this is the increasingly common fight over doctors from pro abortion states mailing abortion pills into states that have strong abortion restrictions and what we do with that interstate mess. So in this case at hand, this is a father from the state of Texas who sued an abortion pill supplier for wrongful death of his unborn children. Um, Tragic as they always are, but also a really interesting case. So, as most of our listeners probably know, Texas law currently bans nearly all abortions in the state and has fairly recently defined aiding another self managed abortion, right? So, abortion pill administration in this case as murder, which I mean, stands to reason, right? If you define an unborn child as a human life in that state, you have laws against abortion because it's murder. Then if somebody is involved in an abortion, they are involved in a murder. This is just kind of a logical reality. So, additionally, in Texas, there was a law passed last year that enables individuals to actually sue somebody who mails abortion pills into the state of Texas. So that is what happened here. A man named Jeffrey Rodriguez recently sued a California based doctor who mailed abortion pills. This is a little messy. So the doctor based in California mailed abortion pills to the plaintiff's girlfriend's estranged husband, who then coerced his estranged wife into aborting not the estranged husband's own children, but this Jeffrey Rodriguez's children with the girlfriend on two separate occasions. So I know there's a little bit of a mess, but the abortion pills were mailed to the ex husband who induced his ex wife to take these abortion pills to abort children who were not actually his. They were Jeffrey Rodriguez's. So hope that's clear. I know it's a little messy. But the long and short of it is Rodriguez is filing a lawsuit arguing that the doctor, in this case in California, his name is Remy Coito. It's a French last name. But the argument is that this was a case of wrongful death. And under the new law, he's also seeking an injunction to prevent this doctor from mailing pills in the future. The pill manufacturers will also be added as defendants to the lawsuit once they are identified by the plaintiff. So the complaint is what you would expect. It states that the doctor directly committed murder by intentionally and knowingly causing the death of the two unborn children. So there's a growing conflict. It's going to be really interesting to see the ways that these kind of legal situations play out. It's a little bit of a mess. So obviously no defense of abortionists, but just noting that it's an interesting situation because the doctors who are mailing abortion pills through the mail are prescribing medication, and I do put that in scare quotes because it's sinister to call something medication when the only purpose of it is to end an innocent unborn life. But as we talked about on the show last week, the federal government has removed the restrictions from mailing abortion pills across state lines without in person doctor visits. Obviously, these abortion pills are quite legal in California. So the doctor's not breaking laws in his home state where he's practicing medicine, although I'll obviously caveat whether the natural law, which is clearly being violated, or the Hippocratic Oath, which is also arguably being violated by prescribing abortion pills. Are those part of the laws that bind all people? That's the question for a different day. I'd say yes. Uh, but the thing here is that right, he's so the doctor's not breaking any California laws, but on the other hand, obviously every state has the right to pass laws and regulate professional conduct within their own borders, right? So Texas has the right to pass laws that protect unborn life in Texas, and professions like medicine are heavily regulated by the state, the professional boards, as well as state regulations and laws. Right? So doctors, like attorneys, and I know this well, know that we need to be very careful when we practice across state lines, right? I'm a Pennsylvania attorney. I know that if I'm doing anything that even starts to look like giving legal advice in another state, for one, I have to be careful that I'm not doing that and engaging in the unauthorized practice of law. But then, if you do have situations where you can give business advice or other kinds of advice in another state, you very well have the duty to know what the laws are, not in your home state where you practice from, but in the state where you're advising people, right? That's just common sense. So you have a duty to know the laws and regulations in the states where you're choosing to cross lines and practice. Right? So this doctor is not being unfairly caught off guard, right? If he's prescribing abortion pills, he knows that he's doing that for a patient in Texas. He knows that he's prescribing pills that are going to be mailed and administered in the state of Texas. So he has a duty as a doctor to know the laws in that state, in Texas, not just in California, and to follow those laws because he's practicing medicine in Texas when he's prescribing pills and allowing them to be administered and taken in Texas. If abortion's classified as murder in the state where he's sending abortion pills, well, it's his responsibility to know that. So this is going to be a continual conflict, right? Post Dobbs, the lines are being drawn. States like Texas, Louisiana, Alabama, and others have passed strong legal protections for the unborn. States like New York and California are aggressively continuing to promote abortion. So if doctors in the latter states are allowed to mail abortion drugs, which, as we've said before, cause about two-thirds of all abortions in this country, if they can mail those drugs into states where abortion is illegal, we have a huge problem, right? If that's allowed to continue, then it's effectively impossible for pro life states to protect life within their own state borders. So I expect these types of cases to continue. I'm curious to see the different ways that opponents of mail order abortion are going to attempt to stop the practice from crossing lines into their own states. And this kind of this giving of standing to file personal lawsuits against people who have procured abortion in these pro-life states is an interesting one. I think we're going to see more of these types of cases. We're going to see some of them go up on appeal, and this is clearly only the beginning, not the end, of figuring out how you deal with pro-life states and pro-abortion states and the easy flow of these drugs in the mail.
Yeah, Frank, thanks for explaining what's going on here. And like you said, this new law from Texas is a creative way to allow and enable people in pro life states to protect the unborn in their state from individuals in states that aren't as life friendly. Now, oftentimes, pro abortion advocates will claim that making abortion illegal will lead to legal action against the women that receive abortions. They can say that, oh, if you're really pro life, why are you going to attack these women that feel like they have no choice? And they paint pro life laws as just attempts to put women behind bars. The reality is that a lot of women who seek out abortions have been misled and coerced by people that stand to gain from their decision to get an abortion. Um, and here in this type of law, in this new lawsuit from Texas, we see a great way to combat abortions by going after providers. The Texas law enables lawsuits against abortionists, those that manufacture and distribute the abortion pill. And I just want to highlight that that's actually how this law works. This isn't an attempt to put, the girlfriend who got the abortions or other women behind bars or behind legal action. This is a way to attack people that are causing the death of unborn children. It's not attacking poor moms who have been convinced that there's no other choice. It's seeking to cut off the supply of abortion from its origin. So it's a simple point, just kind of highlighting how this law works, but it does show how pro-life states like Texas are actually trying to save unborn lives.
Great. I don't think I have anything to add. We have covered quite a bit of ground, from detransitioner lawsuits to forced speech in schools to the ongoing fights over abortion across state lines. So, quite an episode, and we should probably cut it off here. So, thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it. If you like this podcast, subscribe to our channel on YouTube, Spotify, wherever you're listening from. If you want to support the work that we're doing or learn more about it, we always appreciate your generosity and contributions and your interest. And you can find out what we are up to at napalegalinstitute.org. And lastly, if you're interested in the topics that we're covering, if you have suggestions for future topics, cases, things that are going on in the news that we should be aware of, that you'd like to cover, that you'd like to be a guest speaker on, we always appreciate your input. So you can email the info account at napalegalinstitute.org, and we would be happy to hear from you, and we promise we will respond. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. Until then, thank you for joining us, and God bless you.